Today I'm in Los Angeles, California, standing outside the federal courthouse. Today we're going to talk about how damages are calculated for patent infringement in the United States. The reason that I've chosen this location is because inside that building, on a regular basis, judges and juries struggle to calculate the proper damages for patent infringement. The basis for patent infringement comes from statute, and that's 35 U.S.C. Section 284. That section says that the patent owner should receive compensation to adequately compensate them for the infringement. Now, that's a little bit vague. So the statute goes on to say that at a very minimum, that damages should be a reasonable royalty. So the scheme that we have here in the United States is that you have as a baseline the reasonable royalty, but you can also get lost profits. Now, lost profits are quite difficult to prove. Number one, you have to prove that you're a direct competitor. And number two, you have to show that you, as the patent holder, would have been able to capture those sales that the defendant made. So really the analysis of patent damages in the United States focuses on what is a reasonable royalty. Now, that's not an easy question because it's made up of two components. The first component of the reasonable royalty is the percentage, and the second component is the royalty base. Let me give you an example of how this works. There's a Microsoft case where Microsoft was accused of infringing somebody's software involved in a music player on their Windows system. Well, the plaintiff in that case thought that the amount of damages should be based on the price of the entire computer, or $1,000, let's say. Whereas Microsoft was arguing that damages should be based, if any damages were going to be assessed, on a smaller royalty base, such as, for example, the music player itself, which would only have been, probably less than $100. So it's the combination of the percentage with the royalty base that has to be analyzed. And the court has techniques to try to address this problem, but they don't always work that great. We're going to discuss that a little bit more later. For the time being, let me give you the first concept, and that is the hypothetical negotiation. To discuss that, we need to go to the boardroom. Okay, so for this section, we are going to be talking about the hypothetical negotiation. I'm here with Vic Lind, who is special counsel to my firm, and more importantly, a very good friend since I was a boy. Vic, thanks for joining us.
Thanks, Jason.
So what we're going to be talking about with regards to the hypothetical negotiation is to give you an idea of how the court frames how to arrive at a reasonable royalty. Now, this case was first set forth in the 1970s in a case called the Georgia Pacific case, and there are 15 factors that parties are supposed to consider. But in reality, those 15 factors don't always reflect reality. We're going to talk about 4 significant factors that are really kind of divorced from reality and don't reflect a real negotiation so that you can prepare for that if you end up in a litigation situation. The first factor that doesn't really reflect a real-life negotiation is the parties can't walk away. Clearly, in any negotiation, a powerful incentive that you have to compromise is that the parties can kill the deal. Without the ability to walk away, you lose a powerful negotiation tool. Related to that is the hypothetical negotiation assumes validity and it assumes infringement. Now, in any negotiation over a patent license, clearly stating that your product doesn't infringe is a very powerful negotiation tool. Similarly, if you were a would-be defendant and you could find prior art that can maybe put the plaintiff in fear of the invalidity of their patent, that would be a powerful negotiation tool. But again, in the hypothetical negotiation, that doesn't exist. You must assume infringement and you must assume validity. Vic, you've had some experience with that.
That's right, Jason. And I think you've touched upon a really important issue is the parties' feelings about infringement and invalidity. And that's where the timing of the settlement negotiation will be critical, because if you have the settlement discussion prior to an adjudication on these issues, they're going to be more open-ended. After a ruling, one or the other side is going to feel more emboldened in their position.
That's a good point. Now, the third point that is not really in tune with reality is that if you were in reality and you were negotiating, you would be talking about the invention at a time that it was important to you. A lot of times, you're looking way back in time at an invention to try to recapture the feeling that was going on at that time about it. If a patent is good for 17 years and you can litigate at the end of that 17 years, you could be looking back almost 2 decades trying to recapture what the parties would have negotiated a license for 2 decades ago. And that's not easy. For example, if you were looking back on the technology for beta versus VHS, if you had known that beta was going to be obsolete, it would probably give you less incentive to take a license. Another example is CD technology. 10 years ago, I paid over $100 to put a CD into my computer. But nowadays, you can't even get one. That technology has been recombined into DVD and Blu-ray players. You can't even buy a CD player now. So looking back in time and trying to recapture, for lack of a better word, the hype that went into a product and how much you thought it was going to be worth could significantly impact the royalty that you would pay. And it's difficult to go back and try to recapture that. The final factor, and the only factor that really mitigates against the plaintiff, is the fact that the plaintiff may not want to actually license his or her technology to you. If you are the plaintiff's #1 competitor, the plaintiff would quite clearly not want to give you a competitive advantage over them. In order to do that, though, what would have to happen is the plaintiff would have to raise the royalty rate high enough to price you out of the market. And if the plaintiff were to do that, the experts in the case would have a pretty good argument that that royalty rate is too high, and the judge wouldn't accept it. So those 4 factors, although you have to consider them while you're in the hypothetical negotiation, really divorce the hypothetical negotiation from reality. And it gives you an idea of some of the problems that the courts have to grapple with and the parties have to grapple with when trying to affix a reasonable royalty. Vic, do you have any closing thoughts?
I think one closing thought would be, in view of the U.S. Supreme Court case, eBay versus Merck Exchange, a patent owner has to realize that they're not automatically going to be entitled to a permanent injunction if they win the case. So that's something that a patent owner also has to keep in mind when thinking about a royalty or some kind of license, is that he may not be able to get that injunction that they want.
Now, once you've got the framework for the hypothetical negotiation, you have to try to take the next step, and that is to find the royalty base. The royalty base is what's known as the entire market value rule versus allocation. And for that, we're going to take it to the beach. Thanks again, Vic.
Thank you.
Okay. So for this last portion, since we're in California, I thought I'd bring you down to one of my favorite beaches. This is Salt Creek. It's just south of LA. And what I wanted to talk with you about down here is really the whole ballgame when it comes to damages analysis for patent infringement. As part of the hypothetical negotiation and any damage calculation, you'll have to identify the royalty base that we discussed before. So there are basically 2 things you have to understand the royalty base. Will the royalty base be the entire product, or will it be a subcomponent of it? Now, the court has set out some rules for this. If it's going to be the entire product, we have to follow what's called the entire market value rule. And what the entire market value rule states is that the invention, the patent, has to be a really important part of the product. It really has to be the thing that makes it function. It has to be intrinsic to the product, and it has to be the reason that people purchase the product. If you don't have both of those, both the intrinsic nature of the product and the consumer demand, then we use what's called apportionment. Now, let me see if I can explain it to you in a typically Californian way using surfboards. So on my left here, we have a typical surfboard. It's known as a shortboard because it's not really long up at the end of it. And if we were to use this kind of analysis of whether to use the entire surfboard as the royalty base or something else for the entire market value rule versus apportionment, this would be a good example. Okay? So if the technology that you were talking about was based on the entire shape of the board, including the fins on the back, then that would be something that was intrinsic to the product, and people would buy this surfboard because of its shape and the fins on it. But if, for example, we were talking about this leash. Now, this leash isn't what makes the surfboard work. It's an important part of the surfboard, but it's not intrinsic to it. People wouldn't buy this surfboard because of this leash. You can take this leash off, you can use it on another board. So if the patent were for something that was typical to a leash, maybe say the Velcro enclosure on it, then you would use apportionment. And if you think about it, the difference could be drastic, because this surfboard, when it was new, was worth about $300. This leash, on the other hand, is worth about $20. So you would be talking about a royalty base of $300 versus $20, and then you would be applying a percentage to that. Let's say it was 1%. Well, if it was for the surfboard, then it would be $3. But if it was 1% of $20, it would be far, far less. But it's not always that easy, because, you know, sometimes we don't understand the technology that we're talking about, especially when you're talking about computers. Now, if you look over here to this board, now it's similar to the board that we just looked at, but it has some important differences. First of all, it's extremely short, and it's got this rounded nose. In addition to it, the fins, you can take them out. Now, this board is used only in certain conditions for surfing. If the difference between the two technologies were between this whole board and this whole board that I showed you before, well, then it becomes a little bit bigger problem about what drives demand for the differences between these things. And as a result of that, if you apply that to high-tech issues of software that goes into computers, or the hardware that makes it run, or the chips, you can see how the regular person would have a really difficult time discerning the difference between the two. As a result of this, statistically, what we're seeing is that juries and judges are making really big mistakes when they're doing this apportionment versus entire market value rule. A study that was completed in about 2007 showed that 2/3 of the damage awards that were in the United States were either under appeal or had been overturned. In addition to that, jury verdicts were 9 times higher. That's 900% higher than what the bench verdicts were coming out at. And lastly, juries were finding for plaintiff 90% of the time, as opposed to verdicts from the bench or from the judge that were under 50%. So courts have been working really hard to correct this. Some cases, if you want to do further study, are Lucent versus Gateway, Cornell versus HP, IP Innovation versus Red Hat, Laser Dynamics versus Quanta. Now, what this means is much more than the money that goes in to patent damages. What it really goes to is the affordability of access to technology. For example, your cell phone. Considering all of the patents that are out there, if the manufacturer of a cell phone had to pay, 2% of the entire price of the phone for all of the patents that exist out there under the entire market value rule, which is how juries are usually finding these days, the cost of your cell phone would be in the thousands of dollars, and most people couldn't afford it. Similarly, with regard to medicine, the patents that go into medicine would drive medicine through the roof, and the price for that would become even worse than it already is. This is what's known as patent stacking, when one patent after another have to be paid royalties on. So, using apportionment, the courts are trying very hard to bring those values down to real-world values so that people have access to the product and the patent holder gets a fair percentage, but not more than he's owed. It's not just about money. It's about your children being able to call home, and it's about life-saving medicines and life-saving medical techniques that can improve a person's life. So, I hope you've enjoyed this discussion of patent damages. I hope it's given you at least an introductory idea as to what they're about. And maybe in the future, we'll go into some detail on some of these. Thank you.